We have arrived at a unanimous verdict in the challenge to the electoral bond scheme and the amendments introduced to the provision of the Income Tax, the Representation of the People's Act, and the Companies Act, and the RBI. There are two opinions of this court, one authored by myself for Honorable Justice Gawai, Justice Pardiwala, and Justice Manoj Mishra, another authored by Honorable Justice Sanjeev Khanna. Both opinions of this court arrive at the same conclusion, though there is a slight variance in the reasoning which has been adopted. The information about the funding of political parties is essential for the effective exercise of the choice of voting. One of the factors which contributes to political inequality is the difference in the ability of persons to influence political decisions because of economic inequality. Economic inequality leads to differing levels of political engagement because of the deep association between money and politics. There is also a legitimate possibility that financial contribution to a political party would lead to quid pro quo arrangements because of the close nexus between money and politics. Quid pro quo arrangements could be in the form of introducing a policy change or granting a license to the person making financial contribution to the political party in power. The electoral bond scheme and the impugned provisions to the extent that they infringe upon the right to information of the voter by anonymizing contributions through electoral bonds are violative of Article 19(1)(a). We have applied the proportionality standard to determine if the infringement of the right to information is justified. However, we are of the opinion that the third prong of the proportionality standard, that is the least restrictive means test, is not satisfied. The electoral bond scheme is not the only means for curbing black money in electoral financing. There are other alternatives which substantially fulfill the purpose and impact the right to information minimally when compared to the impact of electoral bonds on the right to information. Thus, the infringement of the right to information is not proportionately justified for the purpose of curbing black money and electoral financing. To not grant the umbrella of privacy to political contributions only because a portion of the contributions is made for other reasons would be impermissible. The Constitution does not turn a blind eye merely because of the possibilities of misuse. The Union of India has been unable to establish that the measure employed in Clause 7(4) of the Electoral Bond Scheme is the least restrictive means to balance the rights of informational privacy to political contributions and the right to information of political contributions. Thus, the amendment to Section 13(a)(b) of the Income Tax Act, introduced by the Finance Act 2017, and the amendment to Section 29(c)(1) of the Representation of People's Act are declared unconstitutional. The amendment to Section 182, by permitting unlimited corporate contributions, authorizes unrestrained influence of companies in the electoral process. This is violative of the principle of free and fair elections and political equality captured in the value of one person, one vote. We consequently issue the following directions. A. The issuing bank shall herewith stop the issuance of electoral bonds. B. State Bank of India shall submit details of the electoral bonds purchased since the interim order of this court dated 12 April 2019 till date to the Election Commission of India. The details shall include the date of purchase of each electoral bond, the name of the purchaser of the bond, and the denomination of the electoral bond purchased. C. State Bank of India shall submit the details of political parties which have received contributions through electoral bonds since the interim order of this court dated 12 April 2019 till date to the Election Commission of India. SBI must disclose details of each electoral bond encashed by political parties, which shall include the date of encashment and the denomination of the electoral bond. D. SBI shall submit the above information to the ECI within 3 weeks from the date of this judgment, that is by 6 March 2024. E. The ECI shall publish the information shared by the SBI on its official website within 1 week of the receipt of the information, that is by 13 March 2024. And F. Electoral bonds which are within the validity period of 15 days which have not been encashed by political parties yet shall be returned by the political party to the purchaser, depending on who is in possession of the bond to the issuing bank. The issuing bank, upon the return of the valid bond, shall refund the amount to the purchaser's account.